For this module, we'll be discussing electronic commerce provisions in free trade agreements. When we think of e-commerce in free trade agreements, there are three main issues which are at stake, and depending on the positions on these three different issues, we can see different positions reflected in trade agreements. First of all, there are the commercial interests of firms. So if you look at big firms like Google, like Facebook, they are trying to have their services reach as far as possible to every corner of the world. So because of that, they want to make sure that people in the world can always access their services. At the same time, they also try to reduce the cost. Imagine that Google have to set up a local server in every country it operates in. The cost would be very high. So instead of setting up a server in every country of its operation, Google might choose to have only servers in key strategic locations like US, Europe, Asia, and then to serve other countries from there. So therefore, they are also against various requirements by national government that require them to localize the data on local server. So these two key demands, free flow of information across the border and prohibition on data localization requirements, reflect the interests of business firms. And then on the other hand, if you look at the consumers or the customers of this electronic commerce, for many consumers, even though they enjoy the benefit of all these e-commerce platforms, but at the same time, they are very concerned with their privacy or the possibility of a leakage of a personal data or misuse of a personal data. And because of that, they are most concerned with the protection of personal rights. And last but not least, you have the government, which is the regulator of the sector. Now, for the government, there are two main concerns. First of all, the government wants to make sure that the internet, including the e-commerce platforms, are not misused by certain groups like terrorists and so on, that would pose a threat to national security. And second, the government also want to have the ability to use the data that is available on the internet, including e-commerce platforms, for law enforcement purposes. For example, to trace suspicious criminal activities and people who conduct these criminal activities. So as you can see, among these three players, the firms, the consumers, and the government, they each have different interests. And these interests are all different, and they sometimes even conflict with each other, and that lead to the struggle in different trade agreements. And depending on which interest prevails, you would have different types of trade agreements formulation, as I will discuss later on. In terms of the main platform for regulating electronic commerce, the most ideal forum would be the World Trade Organization, and the WTO has indeed started regulating electronic commerce since 1998, when the WTO members adopted the Declaration on Global Electronic Commerce. But this declaration contains little substance, because it is only a declaration whereby the WTO members agree to look into the issue of e-commerce regulation rather than agreeing to substantive rules. So the only substantive content that was included in the declaration was that the WTO members agree that they would impose a moratorium on customs duties. And such moratorium has a time limit, and it is often only for 2 years. That is from one WTO Ministerial Conference to the next Ministerial Conference. And so far, it has always been extended by WTO members, including the most recent extension in 2019. But the problem is that in recent years, some WTO members started to realize the possibility of loss of customers' revenue because of this moratorium on customs duties. Therefore, they started to challenge this moratorium, and in the future, this cannot be taken for granted. So the WTO Declaration on E-commerce also set out a work program which divided the work on e-commerce to various entities and bodies within the WTO. These include issues relating to services covered by the Council for Trading Goods. Issues related to goods are covered by the Council for Trading Goods, and issues related to intellectual property rights are covered by the TRIPS Council, and issues relating to development are covered by the Committee on Trade Development, and so on. But despite such a detailed work program, the WTO members were not able to reach any substantive conclusion on any of the issues under examination, largely due to the slow progress in the Doha round of negotiations in general. So e-commerce also became victim of this lack of progress in the Doha round. And it was not until 2016 when several key members started to call for new type of negotiations in the WTO that we started to see renewed interest on e-commerce negotiations in the WTO in general. And this further led to the launch of the joint statement on e-commerce by the US and 70 other WTO members at the WTO Ministerial Conference in December 2017 in Buenos Aires. And then finally, the e-commerce talks was launched as a plurilateral initiative in Davos in January 2019. Being plurilateral in WTO terms means that this is a negotiation that not all WTO members participate, only some WTO members participate. And so far, there are about 90 WTO members which participate in this initiative. Now, in the meantime, the forum for regulating e-commerce has been mainly in domestic law and in free trade agreements, and also in the plurilateral initiatives like the TISA. So next we will be looking at the approach taken by the three main players in the WTO, the US, EU, and China, and as reflected in their various proposals in the WTO, in the plurilateral initiatives, and most importantly, in the free trade agreements. So let's first look at the US. For the US, their key demand has been, first of all, ensuring the free flow of data across the border and prohibition of data localization requirements. Because there are so many leading digital firms in the US, and as I mentioned earlier, these are the main demands of these digital firms. Another main issue I mentioned at the beginning is the protection of personal information or privacy, but the US has not been keen on protecting privacy because if you look at the domestic law of the US, even in its domestic legal regime, there is no comprehensive privacy protection framework. Instead, the US only has a patchwork of the sector-specific laws which regulate various areas of privacy protection. For example, in the US, there's a law on credit reports. So this relates to the credit score that you would need to apply for a credit card. So if you want to apply for a credit card, you need to supply a copy of your credit report. And such credit report is very sensitive information because it contains the buying behavior, the payment behavior of the consumers. So therefore, in this law, there's a provision which says the privacy of the consumers for credit reports should be protected. And another law also relates to privacy protection is on video rental. So on video rental, here again, people rent videos, and when they rent videos, they would leave a record, and this record would indicate what type of videos they have rented, and these could include sensitive information. For example, if somebody rent a lot of pornographic video or X-rated video, he does not want other people to know this because this could affect people's opinions on him. So as you can see, the U.S. really took a piecemeal approach where the privacy protection only apply on a sector-specific basis. If you are a consumer, for example, for credit cards or for video rental, then your privacy in these sectors would be protected. But if you have not applied for a credit card, or if you have never rented a video in your life, you do not enjoy the privacy protection for these sectors. So such patchwork of sector-specific laws are coupled with enforcement by the Federal Trade Commission, or the FTC, plus some sort of self-regulatory principles by the firms. So as you can see, the U.S. do not have strong privacy protection laws. And the U.S. has also been very active in including language on its key demands of free flow of data and prohibition on data localization requirements in trade agreements, which include the free trade agreements like the TPP, the Proletariat Initiative like the Trading Services Agreement, and even the WTO. So if you look at the U.S. proposals to the TISA and GSI, you can see that they have included, for example, free flow of information, open networks, local infrastructure, electronic authentication and electronic signatures, and also a long list of prohibition on data localization requirements. When it comes to the free trade agreements like the TPP and the recently concluded United States, Mexico, and Canada free trade agreement, or the USMCA, they also include a list of provisions on the protection of data flow, and also on prohibition of data localization requirements. So in an article which I published 3 years ago, I have basically divided them into several categories. The first are the passive obligations. So this means that these are the things that you should not do when it comes to the regulation of e-commerce. These would include discrimination against foreign digital products, restrictions on cross-border transfer of information, forced localization requirements, and forced transfer of source codes. These also include enabling obligations, so that's another category. Enabling obligations are mainly the obligations to introduce or maintain regulatory frameworks which facilitate the development of e-commerce. So these legislations could relate to the facilitation and recognition of electronic transactions through the authentication and recognition of electronic signature and electronic authentication methods. The third types of provision are the provisions which I would call to check corporate power. So, for example, they include provisions against the misuse of personal information, on online consumer protection, personal information protection, and also against the unsolicited commercial electronic messages. They also include provisions that disciplines how firms can deny access to infrastructure. Basically, the idea is that the e-commerce firms should have a freedom of use to and use of internet for e-commerce. So as you can see, internet here is regarded more as infrastructure services that should be made available for everyone. But interestingly, even though the U.S. agreements are pretty comprehensive, they also include some interesting carve-outs. And here the carve-out, for example, the biggest carve-out are the carve-out for financial services and government procurement and information held or processed by the government. So basically, the U.S. want to retain certain freedom for the government to control information. And for financial services, the reason for the exception under the TPP agreement was because in the U.S., financial regulation is within the purview of the Federal Reserve or the Fed. So the Fed in the internal bureaucratic structure is has more power than the United States trade representative, which is in charge of trade negotiation. That is why in the TPP they actually have a carve out for financial services when it comes to data localization. So in other words, the U.S. financial regulators could require that data be stored locally for financial regulation purposes. But in the U.S. MCA, this approach was changed because the U.S. discovered that actually to make sure that you can have a proper regulation, you do not necessarily have to have local storage. Instead, so long as the financial service regulator can have immediate, ongoing, and uninterrupted access to the information on financial services, then they do not have to require data localization. So it was further relaxed under the USMCA. The U.S. approach also included exceptions which would allow measures necessary to achieve legitimate public policy objectives so long as it's not arbitrary or unjustifiable discrimination or disguised restrictions on international trade, and so long as it passes the necessity test. So let's look at all these issues included by the U.S. in its free trade agreements in detail. The first one is a definition issue. This has been a long-standing issue, long-standing debate in the WTO on whether or not a digital product should be regarded as a goods product or a services product. Now, some WTO members are of the view that they should be regarded as a goods product, especially for those products where the original form was goods. For example, various kind of machineries which are now transmitted through 3D printing. But other WTO members think that they should be regarded more as trading in services, because services compared to goods, one unique feature of services is that it is intangible, and that is also the case for electronic commerce. So this has been subject to a long-standing debate in the WTO, and different members held different views. But the TPP actually took a really innovative approach by actually declining to decide on the issue of whether digital product is a services or trade. So by having a separate chapter on e-commerce, they basically took the classification of digital product outside of the narrow confines of goods versus the services dichotomy. Instead, as you can see in the footnote to the CPTPP, they said the definition of digital product should not be understood to reflect a party's view on whether trading digital products through electronic transmission should be categorized as trading services or trading goods. So in other words, they avoid the difficult issue of a classification so long as you agree to commitments on electronic commerce or digital products. We do not care whether you regard them as services or goods. And this is really conducive to advance the negotiations on e-commerce. The second type of provision is on free flow of data. Now, many of you might think that free flow of data in free trade agreements means that you have to guarantee free flow of data for all kinds of scenarios. But that is not the case, because if you look at the language in the CPTPP, for example, in the CPTPP, it states that each party shall allow the cross-border transfer of information by electronic means including personal information, when this activity is for the conduct of the business of a covered person. So as you can see here, there are several qualifications for the free flow of data obligation. First of all, the free flow of information only applies to activities which is for the conduct of a business. Okay, so in other words, if you do not want to allow free flow data for a given sector, for example, let's say online news services, then you can simply not include this services sector in your schedule, and therefore you do not have to guarantee free flow of information because this would not be for the conduct of business covered. And second, it must be a covered person. By covered person, as defined earlier, this means an investor that is covered by the free trade agreements. In other words, the services must be provided by the investor from one of the partners to the free trade agreement. And thirdly, you could also invoke one of the exceptions clauses to restrict the free flow of data. And this is contained in the provision itself, as you can see from paragraph 3. Nothing in this article shall prevent a party from adopting or maintaining measures inconsistent with paragraph 2 to achieve a legitimate public policy objective, provided it is not applied in a manner that would be constitute unjustifiable or arbitrary discrimination or disregard restrictions on international trade, and so on. And also, most chapters on digital trade also include a provision on general exception, which you can also cite. So again, as you can see from my discussion here, the obligation of free flow of data is not as absolute as you might have imagined. Now next, on data localization provisions. So on data localization, as we can see here, the requirement is that no party shall require a covered person to use or locate computing facilities in that party's territory as a condition for conducting business in that territory. So for data localization, the idea is that you should not require the foreign suppliers to locate the computing facilities in your territory in order to provide business. Again, this is connected with conducting business, so you could make similar argument as earlier. That is, if you do not provide a business, then that would not be covered. And second, as you can see here, similarly, paragraph 3 also include a similar provision like paragraph 3 on free flow of data, where they are saying that you should not be prevented from achieving legitimate public policy objective when you maintain restrictions on data localization, so long as it is not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination or disguised restrictions on international trade, and does not impose restrictions greater than required, or so-called necessity requirement. Next provision is on transfer of source code. Now, this is also a sensitive issue for the U.S. For a long time, the U.S. has been saying that source code is something like a business secret or even the IP rights of its owner, and it should not be transferred. What you see is that in some countries, they would require the foreign service suppliers to supply the source code use in order to provide the services. Now, the official justification is that we want the source code in order to discover if there are security risks and so on. But the firms has been arguing that because source code is such a sensitive information, it could be copied by their competitors if they turn it into the local regulators. So they are unwilling to turn this in. And most U.S. firms do not like the idea of having to transfer the source code. as a condition of providing the services. So this is reflected here, as you can see, paragraph 1, no party shall require the transfer of or access to source code of a software owned by a person of another party as a condition for the import, distribution, sale, or use of such software or of products containing such software in its territory. Okay, but again, here, as you can see here, the software, the source code, the prohibition on transfer of the source code could also be subject to the exceptions clauses, especially for the ones which would be for governmental use, as is common under many RTAs. The next provision relates to non-discriminatory treatment of digital products. Here, again, let's look at the language first. No party shall accord less favorable treatment to digital products created, produced, published, contracted for, commissioned, or first made available on commercial terms in the territory of another party, or to digital products of which the author, performer, producer, developer, or owner is a person of another party than it accords to other like products. So the idea here is that we do not want digital products to be discriminated against just because they are digital products. We want them to get at least the same level of treatment as physical products. Again, this is to promote the development of the digital trade and to make sure that the digital service providers will not be discriminated against. As you can see, the language used here is very expansive. It includes digital products created, produced, published, contracted for, commissioned, or first made available. Okay, so very wide language which covers all kinds of different categories. But in other types of agreements, this might not be the case. I mean, in some RTs, they use narrow language and do not include some of the categories. For example, they do not include publish in this category of activities which is covered. And the next issue is customers' duties on electronic transmissions. Here, note here that the moratorium on customers' duties only applies to electronic transmission, but the WTO one does not does not expand the moratorium to the content of transmission. It only applies to the electronic transmission itself. In other words, you can still impose, let's say, tariff on the content being transmitted. Let's see if this is music download or if this is a movie download, you can still impose a tariff. But the TPP, the CPTPP, actually expand this to cover content transmitted electronically, and that is a step forward compared to the WTO. And the next type of provision deal with the domestic legal framework. So for domestic legal framework, this includes several types of provisions, as I mentioned earlier. First of all, you need to maintain a legal framework governing electronic transactions, along with the principles of the UNCITRAL Model on Electronic Commerce and the United Nations Convention on the Use of Electronic Communication in International Contracts. The idea here is that we want to facilitate the adoption of electronic contracting method so that we do not require the physical copies of contracts. And to achieve these purposes, there are also requirements under the CPTPP for the members to adopt, for example, domestic regulations which would recognize electronic signatures that would facilitate the recognition of electronic authentication method, because one big problem for electronic contracts is how do you make sure that these contracts are really signed by the contracting parties. And for this, unless you have an appropriate method to recognize the electronic signature and to authenticate the identity of the signatory parties, you will not be able to do that. So to have these laws in place would greatly facilitate the adoption of the electronic transaction framework. Similarly, the CPTPP also include provisions to facilitate paperless trading. So the idea is that the trade or customs administration documents could be done in electronic form. Like in Singapore, they have a system called TradeNet, which basically moved all these paper versions of customs forms to an electronic database that is available online. So you as an exporter, before you reach the port of Singapore, you can already complete this form and submit them online, and you do not need to wait at the port to be processed in order to be imported to Singapore. And paperless trading provisions actually is already contained in the WTO agreement on trade facilitation, but many chapters on electronic commerce on digital trade also include provisions on paperless trading, because as you can see, this is closely connected with e-commerce. The next type of provision deal with consumer protection. Okay, so here, as you can see, it states that the parties recognize the importance of adopting or maintaining transparent and effective measures to protect consumers from fraudulent and deceptive commercial activities when they engage in e-commerce. So one big issue for consumers when they transact online is how to deal with online fraud. You know, the cases whereby you do not get what you ordered online, or sometimes you are scammed your money and so on. So this is very important in building the confidence of the consumer in e-commerce, and that is why they include provisions on this. And last but not least, there is also provision on personal information protection, which is basically targeted at protecting the personal information, especially the privacy information of consumers when they transact online. Issues, information such as the name, address, the credit card number, and other sensitive information of the consumers online. Unless you can sufficiently protect this personal information, consumers might not want to transact online. And actually, among WTO members, if you look around, you can see that the member with the best personal information and privacy protection regime is the EU, because the EU now has a law called the Gdpr, the General Data Protection Regulation, which elevates data protection to the highest level in the world. If you recall our previous discussion on privacy protection in the US, privacy protection is regulated as a consumer right. In other words, you only have your privacy protected if you are a consumer in a given sector. But if you are not a consumer in a given sector, you do not have your privacy protected. But the GDPR took a different approach. The GDPR in its clauses actually explicitly recognize privacy as a fundamental human right. So you do not have to be a consumer to have your privacy protected. So long as you are a human, you would have your privacy protected as a fundamental human right. As you can see, that is quite different from the US approach, and that greatly elevated the protection of privacy to unprecedented levels. And similarly, since the adoption of GDPR, the EU has taken an approach that if you sign an FTA with the EU and you want to transfer the data from the EU to your country, then you need to have a privacy regime that either is based on the GDPR or recognized as equivalent to the GDPR or provide adequate level of protection. And so far, about a dozen countries have had their privacy protection regimes recognized as adequate. So that is sine qua non when you try to conclude free trade agreement with the EU. Now, you could imagine that the EU would be taking a strong position on privacy protection in RTA, but so far, the EU seems to be taking a much softer approach because if you look at several of the recent FTAs the EU has adopted, they have either allows the FTA party to adopt their own laws for personal data protection, or they are very loose on the need to guarantee free flow of data. So you are only required to comply with the obligation until after a transition period. I think this is probably because the EU recognized that the GDPR is really intrusive regulation, and they want to give the other parties kind of a transition period for them to familiarize with the GDPR before they apply it on an aggressive basis. Now, last but certainly not least, let's look at another major player, China. For China, the key concern here is cyber sovereignty or cyber security. Because China has a censorship regime on the import of books, publications, or the visual product, including online information, so there's no free flow of information. As we know, many websites like Google, Facebook cannot be accessed within China. And when it comes to privacy, China also does not have a strong tradition of protecting of privacy. It did not have a laws on protecting privacy until 2009. And even after the laws were enacted in 2009, it remains rather weak because there are extensive exemptions for the government contained in the law for the government to get access to personal information. And more recently, in the cybersecurity law of 2017, China also imposed data localization requirements, especially on the operators of critical information infrastructure, a term that is widely defined to capture many different types of e-commerce operators. So as you can see, the Chinese approach is much more restrictive than the US or the EU approach. So that explains why in its trade agreements, China has so far been rather reluctant to include provisions on free flow of data and data localization requirements. Instead, most of the provisions concentrate on the trade facilitation type of issues. So in the WTO, China has been busy with a proposal called the EWTO, which was later renamed as the EWTP, Electronic World Trade Platform, which was initiated by Alibaba and its chairman Jack Ma to basically help to facilitate the regulation of e-commerce and make it easier for the e-commerce platforms to operate around the world. And in the RTs, as I mentioned earlier, if you look at the more recent RTs, for example, in 2015, China signed 2 RTs, one with Korea, one is Australia. The 2 actually include similar provisions when it comes to e-commerce. For example, they both include provisions on moratorium on customs duties on electronic transmission, provisions on electronic authentication and electronic signature, provisions on paperless trading and protection of personal information. And for Australia, they include additionally the provision on transparency, on the need to have a domestic legal framework governing electronic transactions, and also providing equivalent levels of protection to digital trade or e-commerce. But they do not include the common provisions as advocated by the US and the EU, that is, for example, on free flow data and on prohibition of data localization requirements and on transfer of a source code. So why do we have all these different approaches? I argued in another paper that was published 3 years ago in the Journal of International Economic Law that the differences can be explained because of 2 reasons. First of all, they reflect the different interests of these different countries. If you look at the top 10 digital firms in the world, among the top 10, 6 are American firms, 4 are Chinese firms. So what are the American firms? These are typically the digital service firms like Google and Facebook. And for these firms, as you can see, they do not really trade in the traditional trading goods. Instead, they only trade in data, or in other words, they do not trade in atoms, they trade in bits. So because they do not trade in physical goods, therefore, their main concern is to make sure that data can flow freely across the world so that they do not have to establish a server in every country that they operate, and people all around the world can access their services. So that is why prohibition of data localization requirements and guarantee of a free flow of data are among the main demands of the US. For Chinese firms on the list, so the top Chinese firms on the list include Alibaba and JD.com, and both of these firms are actually still engaged in traditional trading goods. The only difference is that they now move the platform of transaction to online platform like Alibaba or Taobao or Jingdong.com. So because they still specialize in physical goods, that is also reflected in China's proposal, whereby China emphasized on the trade facilitation type of provisions, for example, on reducing the customer's or expediting the customer's procedure, reducing the tariff on the smaller volume of transactions, and so on, because they want to sell more physical goods to the rest of the world. So 6 are American firms, 4 are Chinese firms, and there are no U.S. firms, no EU firms on the list. So that explains the approach of the EU, where they have such highly restrictive Gdpr, and some people are saying that the Gdpr is like digital protectionism, is like a protectionist instrument for digital trade. Because they do not have major players, so they enact the GDPR so as to fend off the invasion in their home market from American and Chinese service providers, in order to make sure that their own domestic providers would get the room for growth and would be able to grow without the competition from the American and Chinese firms. So that is one reason, because of the different commercial interests of their firms. And the second reason is because of the different regulatory philosophy of all these different countries. For the US, if you look at the development of Silicon Valley, of the internet sector, they have basically developed with a background of strong history of laissez-faire or non-interference type of regulatory philosophy from the government. And this is reflected in the US laws. For example, if you look at the US Telecom Act, there's a clause which explicitly states that we should make sure that the internet sector remain unfettered by federal and local regulation. So this means that the US believe that the best way to develop the sector is by the force of the free market rather than government regulation. So that is why they leave the sector largely to self-regulation. But for China, for a long time, there has been a long history of a heavy government intervention. So as I argued in another paper I wrote 2 years ago, if you look at the development of the internet sector in China from 1994, when the internet first was introduced into China, the Chinese government has been imposing heavy regulations in the sector. First, regulating the hardware, what kind of gateway you can use to access the internet, and then regulating the software, and then regulating the content of the online platform, and also finally on the regulation of the data. So all along, there is history of a heavy government regulation, and this is reflected in the current state of regulation. For the EU, their focus on privacy protection as a human right can be traced back to their experience with the Second World War, where the EU was the main battlefield, and the atrocities of the Second World War actually taught them the importance of protection of human rights. And that is why the EU, after the war, instituted all these human rights institutions like the European Convention on Human Rights, European Court on Human Rights, and emphasize on protection of human rights. So in the digital age, it is no surprise to see that they continue to emphasize the protection of human rights. Now, you might wonder whether these three different approaches are just an isolated approach among these three WTO members. The answer is no. According to a recent study, which I include in the readings, as you can see, these three different types of regulatory approaches are also reflected over the world. As you can see, the U.S. approach are mainly adopted by countries in the U.S. and some countries in the Middle East. The European approach are adopted by countries like in Europe and also Latin America and Oceania. And the Chinese approach are adopted by Russia and also a few other countries. So these are becoming prevailing models in the world. This concluded my discussion on the different approaches on e-commerce regulation and the free trade agreements. So I will stop here. Thank you very much.